hear the Honorable Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
On behalf of the court, I'd like to welcome you all to the first public administrative hearing of our new term. This is a part of our rulemaking process where we publish the proposed rule changes and invite the public not only to make extensive written comments, which we have on the items up for today, but also to give members of the public an opportunity to address us in session. And in order to facilitate this, we allow each endorsed speaker 2 minutes, which is strictly enforced. So I ask those of you who are endorsed to speak that you conform your remarks so they can be delivered within that time frame. Those are all the precatory remarks. There are, of the items up for today, only 2 have endorsed speakers. They're item 1, which is a proposed amendment of Rule 6.116, designed to consider whether there should be a clarification to the procedure for amending notice of intent to seek an enhanced sentence by requiring any such amendment to be approved by the court, and it would eliminate an existing provision which precludes harmless error analysis. The court has received comments from a number of people, and our first endorsed speaker, let's make sure I've got the is the second amended inclusive of the others? I'm sorry? I have the second updated, but it looks, I got it. Okay, I'll just go from the updated. All right, the first endorsed is Mr. Christopher Smith on behalf of the State Appellate Defender Office. Good morning.
Thank you, Mr. Chief Justice, and may it please the Court, on behalf of the State Appellate Defender Office, I'm here to speak in opposition to the proposed amendment to Rule 6.112. Our view is that largely this is a rule that's a proposal that will create more problems than it will solve. I think cases where the prosecution is unable to meet the 21-day deadline are relatively rare, and it's a system, it's a bright line rule that has been in place for 2 decades, and again, in the 21st century, information on the defendant's criminal history is available to the prosecution at a click of the button, and the 21-day bright line rule has rarely posed problems, I think, for the prosecution. Conversely, by creating sort of a harmless error exception to that rule, you're creating the danger of depriving the defendant of notice of the sentence that he or she is going to face upon conviction at trial. And this is going to compromise plea negotiations. It's going to compromise counsel's ability to provide the effective assistance of counsel during plea negotiations. And in some, it creates more problems than it eliminates. And so we would ask the court to keep the rule as is and not accept the proposal. Thank you.
Any questions? Thank you very much. Ann Yantis, Director of Clinical Programs, U of D, Mercy.
Good morning, Your Honors. Ann Yantis from the University of Detroit Mercy School of Law. I wanted to make 2 points in addition to the letter that I submitted to the court in opposition to the proposed court rule amendment. The cases that I cited in the letter, if you look at them factually, one of the motivating forces behind the Supreme Court's decades of litigation and decisions on this and having a firm rule for the timing of the filing of the habitual offender information was to avoid the appearance of impropriety. And factually, in several of the cases, what you're seeing were cases where the prosecutor had knowledge of the convictions, but waited until right before jury selection, the day of trial, to file the supplemental information, waited until the day of sentencing, waited until after sentencing, and in one case waited 4 months after conviction and after the defendant's appeal period had expired. So it has the appearance of impropriety, and that was one of the two reasons that the court eventually settled on a 14-day rule. The other reason being that you need to have early notice on the part of the defendant so that you can prepare, that you're aware of the consequences. The other point I wanted to make is that the 1929 law actually allowed the prosecutor to file after conviction or after sentencing, and that was adopted into the 1931 code. And it may be that there were very good reasons at that point to allow the prosecutor to have more time. I assume it was more difficult to obtain information about convictions from other jurisdictions, in part because they didn't have the internet, they didn't have email. I would assume the availability, cost, and use of the telephone was probably less than it is now. What I've not heard in terms of this proposal is that prosecutors don't have the ability to find out the information they do within the current 21-day period. So we'd ask you to not adopt the proposal.
Thank you. Any questions? Thank you very
Thank
much. The next endorsed speaker is Diane Ferguson. Ms. Ferguson does not have you. Donald Ferguson? Keith Olson?
Hello, my name's Keith. I'm from CRAP, Criminalized Racketeering Against Patients. I had a case come across your desk last year, number 150-135. I put the exact same arguments through as the Carruthers dispensary cases. My argument wasn't picked up. I suspect y'all are going to pick up Carruthers in the next week or so, and I have quite a problem with the Court of Appeals deading every medical marijuana argument with the line that medical marijuana dispensary is illegal under state law. 2008, 63% of our voters passed the voter initiative, the Medical Marijuana Act.
Sir, are you addressing the item 1 on our agenda?
Do I have 3 minutes to speak and do my thing and get there, or am I going to be interrupted this whole
No,
time?
I just want to know, so far,
Your
I'm
telephone's
going
on,
to have to find
sir.
myself.
That's for me, I'll call back.
This is
been
extremely
quite a
rude.
morning already.
I would like to add that the officer out front harassed us for a minute and a half.
Go ahead.
Demanded our phones were turned off.
Continue.
Demanded inspect our phones. And now my speech is interrupted by a telephone call.
You may continue, sir.
Is this took away from my 3 minutes?
Please continue. You can have your minutes.
In 2010, Bill Schuette began a crusade against the medical marijuana patients. Under Bill Schuette and Rick Schneider in Michigan, and the rest of the entire country have suffered. Citizens United, the Medical Marijuana Act, the attack on progressive families, offended and hurt the whole country. Present-day patient status in Michigan, 0 defense in court, 10,000 families every year burn for the Medical Marijuana Act. The last three winners of the Supreme Court, Tuttle, Hartwick, and Missouri, I'm sure you know their stories. Tuttle got a year in prison. Miss Missouri got 3 felonies, a divorce, and a bankruptcy. And Richard Hartwick got sentenced to 2 to 15 years in prison. Now, he went back. You can picture a guy getting sentenced to that kind of time, being all shook up, worried. He gets back. They slide a sheet under his door, his sentence. The frequent flyers at Oakland County tell him 2 to 15 years at sentencing, then slide a sheet under the door that says 2 to 40 years without even so much as telling the guy. That kind of stuff's criminal on every level. Us patients have not received one beneficial ruling, one beneficial policy, one beneficial program whatsoever. I wanted my case to win, but now I'm glad it didn't, because I see what's happening to all these winners around here. Now, for a decade, the appeals courts have entered into a criminal conspiracy with the Attorney General. Bill Schuette's been pulled up out of the appeals courts to just sabotage and destroy everything humanly possible and manipulate the process and the checks and balances. And I say you all are allowing him to do so. Now, he used one silly little dispensary opinion, the McQueen decision, to criminalize 250,000 people's actions. No defense whatsoever. You stand on that for 3, 4, 5 years, attack the community. They do it again under Hartwick Section 8, attack the community for 4 or 5 years. Now they're coming through with city ordinance, attacking us in our cities. I already said they can't do that. We're going to have to put up with that for 6, 7, 8 years. I'm here today to tell you all the war on drugs is over. With any drug war, with any war, sanctions will be made after the war. We hunt Nazis 70 years after World War II to this day, to the edge of the earth for the atrocities they've committed on the public. It's time to change Michigan. It's time for y'all to stop this absurd behavior against us as patients. And it's time for y'all to pick up Carruthers and stop these cops from showing everybody fake IDs made on state computers, completely illegal. All the rulings out of the West Coast, y'all know them. Y'all know everything coming out of the 9th District. You've read them. In California, it's illegal to charge me $100 for a medical marijuana card to give me a defense. It's 100% illegal when there's a free defense available. There's a free defense available in Michigan. It's called the Section 8 of the Medical Marijuana Act. In a decade, 3 people have presented Section 8 to a jury in a circuit court in Michigan in a decade. All 3 of them had to come up here, back and forth, and back and down twice. Go back, pay a lawyer $200,000. Countless patients like Tory Clark have spent their last days on earth being tortured while they're ill, sick, and dying, and have to put up with the abuse that's coming out of here. You know, I've tried to be nice about it, I've tried to be polite about it, but when nobody picks up anything, nothing's taken seriously, y'all just railroad us into the ground for 10 years. And now we got to deal with guys like Clint Kesto, Mike Colleton, and Rick Jones, creating a whole new industry now, pushing these House Bill 4209s through today or tomorrow, while you're going to let them sell us all drugs, while we all have zero defense. You know, they're going to sell my kids drugs. The kid's going to walk across the street, one of Rick Jones' buddies going to see him, yank him out of the car, beat him up, steal the car, put him on probation, put a black mark on their record so they can't get a job. If they're in college, they lose their financing. I had a 3.85 in college, 3.85 GPA in college when this happened to me. I woke up that morning.
Sir,
I was a college
I've
student.
given you more than enough time. Would you conclude your remarks?
Yes, sir. I'd like to say that I woke up that morning a college student, a family man with a business, a tax-paying citizen, and I went to bed a convict on a concrete floor without a blanket. And I ain't putting up with it. 10,000 people a year, 10,000 families a year ain't going to put up with this. We've been sitting waiting quietly for 6, 7 years for a positive ruling. We haven't gotten it, and it's time for y'all to come correct.
Thank you.
Criminalize racketeering against patients today. Would you all have any questions I could educate you on?
Thank you very much.
Anyone? Ms. Larson?
Thank you very much, sir. Keith Olson. I'm sorry, Stephen Scully. No.
Again?
No. Forgot to check your name.
Hello.
You have
I am
3
deeply
minutes.
honored to be here in front of you. I did not expect to be here. I thought I would be speaking to some representatives. So this was prepared for representatives, so I will be skipping and things like that. But I prepared it and I will get to the point. And yes, this is about medical marijuana. This is about people in jail while others are allowed to sell marijuana. There's 70 dispensaries in Lansing right now. You all know that. A man in charge of U.S. drug policy for 32 years once stood on the stand in federal court and stated he took 2 puffs of marijuana and turned into a bat. That was Harry Anslinger and his prohibition stance on marijuana's practice today. He was never removed from office and charged with lying on the stand, obviously a crime. The part of marijuana prohibition that is not spoken about is the slavery. People do not mention the slaves paying restitutions. People do not mention the slaves in prison. They do not mention the fees and other blatant violations under the U.S. Constitution. Prisoners regarding cannabis, marijuana's real name, are in the thousands in Michigan. We all have lost loved ones to cancer. We all have lost loved ones to other illnesses that cannabis can help. Some of us have lost loved ones to prison and the other part of the cannabis war. Dispensaries are needed. Cannabis oils and medibles are needed. The things that they are doing in our buildings over there right now are not needed. In Michigan today, people will go to jail for cannabis. They will be asked for money. They will be hauled away for cannabis. I passed 9 dispensaries today on a 10-mile journey into Lansing. Lansing is a safe zone. A group of individuals, including its mayor, champion for what the people voted for 8 years ago, but has been since destroyed with policy. I am literally a refugee in my own state. My life in limbo, my crime, owning a dispensary, not in a safe zone. We did pass an ordinance. I did pay taxes. I was registered with the city and the state. Still raided. So now I live hundreds of miles from my real home in beautiful northern Michigan. It's insane to think this is real, facing 8 years while hundreds do the same. 8 years of complacency has done this to me and thousands more. The only aspects of the MMMP that work have been implemented without the manipulation of Lansing. The people asked for it and voted for it. The people implemented dispensaries because Lansing was not going to, and they work and they help.
Please conclude your remarks, sir.
This is not a democracy. It does not represent us. Monopolizing cannabis, putting people in prison, is not what America is about. Sic semper tyrannis.
Thank you, sir. Those are all the endorsed speakers for item 1. And we'll go to item 2, which is proposed amendments to several different court rules that would permit courts to expand the use of video conferencing technology in many court proceedings. The first endorsed speaker is Judge John Tomlinson. On behalf of the Michigan Probate Judges Association, correct?
Hi, that's correct. Thank you, Mr. Chief Justice. Good morning. I'm here, I'm St. Clair County Probate Judge John Tomlinson. As I've mentioned, I'm here on behalf of the Michigan Probate Judges Association. I thank the court for the opportunity to address it regarding the proposed amendments to the Michigan court rules. Our concerns are really with MCR, the proposed MCR 5.738A, large A. We believe that the proposed amendment removes discretion from the trial court to determine the location of the hearings. As we mentioned in our letter to the court, there are nearly 20,000 petitions filed for involuntary mental health treatment in the state of Michigan every year. Because of the location of the mental health units, there's obviously a limited number of secured facilities. Limited number of mental health professionals. There is a dearth of psychiatrists that are available or other mental health professionals. And the safety of the respondent and other people when we're trying to conduct those hearings. The video conferencing technology permits us to do things that we would not otherwise be able to do. From a personal experience in St. Clair County, we oftentimes use that video conferencing technology to conduct hearings with participants or respondents that are at the Kalamazoo Psychiatric Hospital, Center for Forensic Psychiatry in Saline, the Carroll Regional Center. So we're able to provide continuity for those respondents that otherwise required an assignment of a judge or something else, and there was a difficulty to make sure that there was continuity. It's also utilized to permit psychiatrists to testify from remote locations. The psychiatrist has a practice, they have things that they're doing, they're at the hospital, they're working. To have them come to a court hearing to testify for one individual ends up impacting numbers of other individuals because they're not available to do what their primary job is. Our concern is, as drafted, video technology can only be utilized if the subject of the petition does not object or other certain circumstances. All we are proposing is that there be phraseology added that upon a showing of good cause, the court would be permitted to use that technology even over the objection of the respondent. That lets us permit respondents the opportunity to consider the use of video technology, but gives the trial court the ability to determine that other good cause, safety of the participants or other people, convenience of the parties, or disruption of the subject's treatment would warrant the use of the video technology. We also oppose the language of A3. It does not permit the trial court to consider the safety of others. My personal experience, the one time that I've excluded a respondent from a hearing in the 10 years I've been on the bench was his aggression to the deputies that were transporting him. It ended up in physical damage to the courtroom. Nobody was hurt, but it could have been. I then required him to participate from the jail through the video conferencing technology. If I had to worry just about his safety, that may have been not the decision that I would have made. So I would just like to add the phrase "or others" to provide for that discretion. Thank you for the opportunity. I'd be happy to answer any questions the court may have.
Thank you very much.
Okay, thank
Judge,
you.
just one
Have a good day.
question. You're not suggesting by court rule that we should set up a system that would be in conflict with statutory provisions, are you?
Absolutely not. We're just looking for some kind of acknowledgement of discretion in good cause. I think that there is obviously an ability for the respondent to say there's an objection. If the objection is not well-founded or we think there are other considerations that outweigh that, then we can talk about doing something different. Oftentimes, the video is used to permit the respondent to participate wherever he is or where the doctor is. I would think the likely objection would be is I want the doctor here in person, or I want to be there in person, and we can configure things. We go to the hospital, we do all kinds of different things, so we'll be able to figure it out. There may be circumstances, if I had somebody at the Center for Forensic Psychiatry that wanted to be in my courtroom and wanted the doctor there, that ends up being a 3-hour trip for both the respondent and the physician to come to my courtroom to have a hearing, when we could do it in 10 minutes by video with them both in the same room.
Just so we're clear, you're here representing the association. That's the same for courts all over Michigan, right?
Yes.
Who have patients at Caro or other
Yes,
institutions?
and especially Kalamazoo, Center for Forensic Psychiatry. There's Ruther for Wayne County, and then there's Caro, I think, for the rest of the state. So we've handled the hearings at Caro traditionally by having kind of a rotation. People cover them at different times. As I mentioned, the continuity is very difficult. I may go to Caro to have hearings. I might not see anybody from my county. I might get 3 from Macomb and 2 from up north, and not
Has the
know who
video
these people are.
conferencing eliminated that rotation system that used to be in place?
It has eliminated to some degree. I still participate in the rotation, but I hear all the cases of people from my county.
Okay.
Okay. Anything else? Thank you very much. Have a nice day.
The next endorsed speaker is Ann Yantis.
Good morning again, Your Honors. Ann Yantis from the University of Detroit Mercy School of Law. I am here to oppose the amendment as it relates to felony sentencings and video conferencing. I apologize for not having filed something in writing. I missed this proposal as I moved between 2 jobs. There's a recent decision of the Court of Appeals that's published. It's called People v. Heller. It does a very nice job of explaining why it's important for a defendant to personally appear at a felony sentencing. There is something, though, that I thought could be added to that decision, which is there's an important therapeutic aspect to the defendant's allocution as well as the victim's allocution. It's recognized in the law. The defendant has the right to speak, and they may not have spoken at all during the proceedings. This is their opportunity to say something, perhaps to explain the crime, and that can be therapeutic for the defendant and also the victim to hear that. The victim also has a right to speak. It's their opportunity to say their feelings about the crime in the presence of the defendant and often looking the person in the eye, and that is lost when the defendant appears by video. In terms of structuring this as the defendant can consent to this, the problem is that there can be a fair amount of institutional pressure for the defendant to waive the right to appear at sentencing. That can come from defense counsel, the court, or the jail or the prison. I had a case in Wayne County where the judge granted resentencing and then wanted the defendant to appear by video. And apparently that was the judge's practice, but we said no, he would like to appear in person. I indicated to the judge that I thought there was no authority for him to appear by video. Judge asked me to brief it. I did. I would say that she reluctantly agreed with us. The resentencing went forward. It didn't go the way we had hoped. We don't know if that had an impact on it. But I had to have a discussion with the client before we decided to push for his personal presence in terms of, will this anger the judge? Will this not help you at sentencing? And we shouldn't have to have that discussion. You do not want to anger a judge at sentencing. You don't want to appear to be wasting resources, but that shouldn't come into the discussion. That shouldn't be something that is even a factor at sentencing. Felony sentencing is so important, and practically speaking, there are things that arise on the spot that you need to be able to consult with your client about, and if they're not physically present, you can't do that. And then also in terms of the credibility factor, there are some studies, and this is mentioned in the Heller decision, there are some studies showing that a viewer's perception of the credibility of a person who appears by video can be less, so less trustworthy, less credible. You do not want that at sentencing for a defendant. This is your opportunity to speak to the court, to show the judge who you are as a person. You need to be able to do that in person.
Thank you.
Counsel, may I ask a question? First off, thank you very much for coming and congratulations on your new position. Help us to balance, and I was listening very intently to everything you said, but I guess if you could address the balance that the court has to be concerned about. You recall a number of months ago there was a defendant that I believe killed 2 bailiffs, while being escorted, and that was a very, very tragic day for the court. So I guess the issue is that there is some kind of a safety component that comes when you're dealing with circumstances and situations of this nature. And if you have a person who is perhaps facing life without parole, it could ultimately create a situation where, they don't have much to lose. And I guess if you could help us to balance the issue, of course, with the ability to be present, and it's your right to be present, with the concern that law enforcement has, which is the inherent danger that comes with transporting people in this situation.
Well, and I understand your views, Justice Bernstein. I think the problem is that you have an absolute right to be present, and for a felony sentencing, it's especially important because it can be a significant deprivation of your rights to liberty and to live in society. So the impact.
I guess I'm concerned with the nature of the argument. You're saying we should deprive a defendant of the ability to waive this and only this constitutional right? I mean, almost every constitutional right can be waived, right?
Most can, yes.
Yeah, almost. So why is this one
Different?
so singular that a criminal defendant and his or her lawyer couldn't decide that this might be in the interest of the defendant to conduct that by video?
And 2 reasons. One is that, as I said, there's a great deal of institutional pressure to waive it, even if it's not in the defendant's best interest. And even defense counsel can urge the defendant to waive it because we don't want to anger the judge. Well, that shouldn't be a consideration. It just shouldn't be. The other point is that
Counsel?
go back to the allocution.
Counsel, I'm sorry. Is that meaningfully different than allowing a criminal defendant to waive trial altogether and plead guilty? There are pressures there too. So I guess I'm not seeing why we would allow you to waive trial altogether and not allow you to waive sentencing. What's the argument about why those 2 things are different?
Well, sentencing in many ways is a subjective decision by the sentencing judge. And so it's critically important that you try not to anger the judge as you're appearing in front of the judge's sentencing, because it's really unclear what will happen and what the length of the sentence will be. The judge has a fair amount of discretion. So, you have to make judgments about what arguments you make and what you don't. But, to be able to say that, well, I shouldn't appear in person because it'll be more favorable for me, that is the pressure. And that shouldn't be there for a felony sentencing.
I'm not sure. I would have thought that one answer to Justice Larson's question was, it's not the difference between waiving trial and waiving sentencing. You're not waiving sentencing. It's waiving the right to be present during the both. Can you waive the right to be present during a plea? Can you plead guilty from jail? Should you be able to? Maybe the answer is yes, but I don't see the right to be present as the same as waiving the right
Well,
to trial.
and I wanted to go back to the allocution aspect. I mean, that's not, you don't have that at the time of the plea. At sentencing, it brings in a lot of parties, and there's this opportunity for everyone to have a say. There is a therapeutic value, and I have seen situations where the defendant turns during allocution, turns to the audience and offers a sincere apology to the victim or the victim's family. You lose that if the person appears by video. And the victim loses the ability to speak in front of the defendant.
Thank you.
Do you
Are there any
believe
other
the
questions?
victim should be given an opportunity to object?
Well, I think we shouldn't allow defendants to waive this right. It's too important, and for the very few cases where perhaps the decision, the sentence is already given,
But
even
if
for
we allowed the
screen
victim
murder.
an opportunity to object, that would alleviate your concerns relative to the victim, would it not? In other
But it
words,
wouldn't-
if the victim consented and said, you know what, I don't really feel the need to see this defendant in court, I don't need to go through that.
Well, it won't alleviate the defendant's right to speak in person to the court, and it doesn't alleviate the fact that you've got the problems with assessment of credibility by video. It's an
I
intensely
agree.
human.
My question was a little more focused to one part of your argument, not to all the others, but I understand.
Yours seems to me to be really a more fundamental criticism of the video conferencing procedure than it might appear at first blush. You're suggesting it's not simply a difference in mode and the type of presentation, but also that in light of the credibility impact and the therapeutic effect, there's really quite a substantive difference between these two circumstances, are you not?
There is, and we have been using, I say we, the State Appellate Defender Office, when I worked there, we had the ability to meet with clients through the video conferencing equipment rather than in person. And sometimes if you received a case that had an immediate deadline and the person was in the Upper Peninsula, sometimes you did that. But you missed things through that type of conference. The case of People versus McGraw, I represented Mr. McGraw. We were appointed at the last minute in the Supreme Court. And I was completely unaware of the fact until I met him at the later resentencing that he had some facial deformity, and he was actually a very shy man. And none of that came through on the video conference. I had a very different perception of him when I met him in person. I also had a client who has some serious mental illness, and really I did not pick up on that during the video conference, although I picked up on it when I met with the client in court. So there are things you miss through video, and they're important.
Thank you.
Thank you.
Sean Bennett. Diane Ferguson. Donald Ferguson. Those are all the endorsed speakers on the matter. There being no others, we are adjourned. Thank you.